The one thing you must do when you hear RUMINT, the critical first step for senior officers. The second you hear word of criminal allegations against you, whether from your first sergeant, a trusted NCO, or somebody who saw someone going into an investigator's office, you must do this first before anything else. Look, I know what you're thinking. You've got decades of service. You're relied upon. The mission needs you. You've built your career being the person who handles things, who stays calm under pressure, and who leads when others panic. But here is the brutal truth, and I'm not going to sugarcoat this. None of that matters if you don't handle the first moments correctly when allegations hit. I'm Joshua Tolan, and I've spent over 15 years in the courtroom, more than a decade in military law, both as a senior prosecutor and a senior defense attorney, focusing on court-martial cases for officers and senior NCOs. Unfortunately, throughout my military career, I saw horror story after horror story of degraded officers, colonels, lieutenant colonels, senior NCOs who'd led troops in combat, losing everything because they did the wrong thing in those critical first hours. Combat veterans with spotless records, gone. Careers destroyed. Families shattered, all because they trusted a system that no longer protects them the way that it used to. So in this video, I'm going to walk through the exact step-by-step protocol that can save your career when allegations surface. This is the same emergency playbook I give officers and senior NCOs who call in crisis. And let's be real, if you're watching this video, you're probably in that situation right now, or you know someone who is. So pay attention, because what I'm about to tell you could be the difference between keeping everything you worked for and losing it all. Stop everything. This is a family emergency. First, before anything else, and I cannot stress this enough, you need to stop time. The second that you hear word of criminal allegations against you, whether that be from your first sergeant, a trusted NCO, from a supervisor, from somebody who likes you, who saw somebody going into an investigator's office, from the instant that you believe there could be something negative against you, you must pause, stop, freeze, pause X, whatever terminology you want to use. You need to stop time and focus on this family emergency. Now, I know what you're thinking. Of course you have lots to do. You are incredibly busy. Your job, the mission, needs you. You have built your service over decades, and you are relied upon. However, this is no kidding a family emergency. And let's be real, you probably have countless days of use or lose leave anyway. Just pause what you're doing, take the time, and take a deep breath. Here's what I mean by that. Don't do this from your office. Don't do this with a spouse or your kids around. Go somewhere private, get in your car, drive somewhere, or lock yourself in a room where nobody can interrupt you. And just stop. Stop everything else. Unfortunately, I've seen too many officers try to handle this while juggling their normal mission duties. They think they can compartmentalize. They think they can keep leading their troops simultaneously while dealing with the biggest crisis of their professional life. That's the first mistake that costs them everything. Because when you're trying to do both, you're not doing either one well. You're making decisions in a fog, and those decisions in the first 72 hours are the ones that can determine whether you get to keep your career or lose it all. Let me tell you about a case I prosecuted against an officer. He finds out from trusted colleagues that he's being investigated and what the allegations were. Instead of stopping everything, he spent the week trying to fix it himself. He called people, he tried to explain his side, he even created evidence on his phone. And by Friday, when the investigators called him in, he laughed and chatted it up with them, thinking he could smooth over things easy peasy. And they bought it, hook, line, and sinker. But when you're accused of a crime, it is not OSI or CID or NCIS that you have to convince. By talking with witnesses that week, selling his version of events, by giving investigators false information, this war hero shot himself in the foot. He had created so much additional evidence against himself that what might have been a manageable situation became an absolute disaster. He ended up losing his career, being dismissed from military service. A dismissal is the officer equivalent of a dishonorable discharge. He lost his right to vote, to have a gun, his retirement, everything. All because he didn't stop and think clearly in those first critical hours. So when I say stop everything, I mean it. This trumps the mission. This trumps your duties. This is your life, your family's future, your legacy on the line. Get your mind clear before doing anything. When you stop everything else, there's going to be a few things that you're going to need to focus in on. You're going to focus in on making sure that you can think as clearly as possible about everything that you know happened. Everything that you know, who may have been around, any interactions you've had, and you're going to think about what kind of evidence might exist. Now, at this point, we don't even know what the allegations are. We generally have an idea, usually about what they are because of your interactions with that person, the person you know to be the alleged accuser. But even if you think it's one particular event, oftentimes that is not the case. Here's the thing. Often when somebody makes allegations or actually reports real instances, they exaggerate. And oftentimes, additional allegations are raised that you weren't even tracking. So what you have to do is stop and think about all of your interactions with that person in as clear of a mindset as possible. Let me give you an example of why this matters. Another case I prosecuted in the Air Force started with shop rumors about how an NCO was treating 2 female airmen. The rumors made their way to the accused before he was questioned. But the rumors weren't about mistreatment. Instead, they were about giving these 2 women extra attention to the shop's detriment. Had he gone to a lawyer as soon as he heard that rumor, an experienced military defense lawyer would have asked some very specific questions, so the accused and that lawyer could have thought about all of the interactions and been more prepared. Instead, that NCO was charged with very serious offenses, stalking, and multiple allegations of sexual assault. That accused was blindsided because he hadn't thought through all of his interactions with those 2 people. He hadn't considered what evidence might exist from those other events. And because he had not done that mental work up front, the defense was playing catch up for months. When your career and your family's finances are on the line, there is no reason for you to make it harder on you and the rest of your defense team. You're also going to think about all of the evidence that exists. And what you're going to do before anything else, once you're in that clear mind state and you have really thought about what kind of evidence exists, what could exist, what you know, you're going to map it out in your head. Think about text messages. Think about emails. Think about who was present at the various events with that person. Think about social media interactions. Think about any photos or videos that might exist. Now, it's very important. Do not destroy evidence. That can result in more serious charges for obstruction of justice, which is prosecuted under Article 131B of the Uniform Code of Military Justice. For your defense team to help give you the best advice, you still want to think about what evidence could exist. But you can't clearly think about that until you stop what you're doing and take a deep breath. And really, actually think about all of those interactions that you've had with this particular person. This is not something you can do while you're sitting in your office between meetings. This is not something you can do while your spouse is asking, "What's for dinner?" You need complete mental clarity, and that only comes when you remove yourself from all the noise and distractions. Find the right lawyer, not just any lawyer. Once you've collected yourself and you've thought through everything clearly, you need to find a lawyer. And you don't need to find just any lawyer. You need to find a lawyer with experience in military law, specific experience in defending the most serious allegations. And here's why this matters. You don't yet know what the allegations are. Maybe it's somebody that you had an extramarital affair with. Got it. You might be worried about that. But often, especially against senior NCOs and officers, extramarital affairs turn into allegations of sexual assault. Extramarital affairs turn into allegations of failure to follow superior commissioned officer orders. Extramarital affairs turn into derelictions of duty. What starts as one thing can quickly morph into something much more serious. And if you hire a lawyer who only handles minor UCMJ violations, or worse, a civilian attorney who doesn't truly understand the current status of military law at all, you are setting yourself up for failure. Unfortunately, I see this all the time. Officers hire their buddy's lawyer, or they go whoever is the cheapest, or they think that any JAG experience is good enough, but it's not. Once you contact that lawyer, and you might actually contact more than one, importantly, you need to find a lawyer that you can trust that has relevant, recent experience in dealing with your kinds of issues. And once that happens, you're going to get legal advice from that lawyer. Oftentimes, that legal advice includes not talking to anybody else. That falls into pausing and freezing what you're doing. You're not going to talk to anybody else about these allegations because every one of those people becomes a potential witness. Think about that. Your first sergeant who you confided in, potential witness. Your buddy who you vented to over beers, potential witness. Your spouse who you told your side of the story to, in some cases, potential witness. Every conversation you have before you talk to a lawyer is a conversation that can be used against you. Your lawyer is probably going to talk to you about how to preserve evidence and what evidence to think about preserving. That lawyer is probably going to talk to you about how to stop investigators from accessing your private details without search authorization. That means locking down your personal information, getting rid of biometric access to your mobile device. That means locking down your social media. All of the things that we think about OPSEC, operational security that we use in military operations, you now need to apply to your personal life. Once your lawyer learns the specifics about your case, your lawyer should be giving you specific legal advice tailored to your situation. Listen to that advice. Your lawyer may also tell you to talk to nobody generally, but they may specifically tell you not to talk to investigators, to be in listening mode and to report all the information to your lawyer. Let me be clear about something. I am not telling you this because I want to make money off of scared officers. I'm telling you this because I've seen what happens when you don't do this. I've seen officers who thought they could handle it themselves. I've seen officers who thought their record could speak for itself. I've seen officers who've cooperated fully with investigators thinking the truth would simply prevail. And I've watched those officers lose everything. Lock down everything. OPSEC for your personal life. So let's talk about what locking down actually means, because this is where a lot of officers make critical mistakes. First, your phone. Right now, if investigators wanted to, they could potentially access your phone if you've given them biometric access or if your phone is not properly secured. Get rid of Face ID or fingerprint unlock. Use a strong password that only you know. Why? Because if investigators show up with a search authorization, they cannot compel you to give them your password, but they can hold the phone up to your face or press your finger to it. Second, your social media. Lock it down. Make everything private. Now, it's incredibly important. Do not delete anything. Doing so can be considered destruction of evidence, but you are allowed to make sure investigators cannot just simply scroll through your Facebook, your Instagram, or your X without authorization. I've seen cases where good investigators and prosecutors have built their entire case from publicly available social media posts. Third, your email. If you've been using your personal email for anything related to this situation, you need to understand that that could be discoverable. Again, do not delete anything, but you need to be aware of what is there. And for the love of God, stop sending emails about the situation to anyone except your lawyer. Fourth, your text messages. Same thing. Don't delete, but be aware and stop texting people about the allegations. I don't care if it's your best friend from high school who lives across the country. Every text is potential evidence. Now, something that needs to be absolutely clear, if it isn't already, I am not telling you to destroy evidence. And if your lawyer tells you to, that is a huge red flag. I'm telling you to protect your privacy and to make sure that investigators have to go through proper legal channels to access your information. There is a big difference. Destroying evidence is a crime. Protecting your privacy is your right. Here's a real example of why this matters. Another case I prosecuted. This one was against a senior NCO with 24 years of service. Stellar record, trusted up and down the chain. Then allegations of domestic violence came up. He didn't pause, he didn't lock down his communications, his social media. Instead, he started a PR campaign against the alleged victim, using his phone, text messages, social media. She's crazy, she's exaggerating, we all know it. He corralled the troops. It was not hidden, it was public. Once again, this senior NCO was a trusted troop. He knew how to get things done. In fact, he convinced a slew of supporters she was lying through his phone. An experienced prosecutor will use that against you. And that's exactly what happened at this trial. His credibility was shot, and that ended his career. 24 years of perfect service, gone. Punitively discharged for his crimes. You can learn from his critical mistakes. At the end of the day, everything you do in these first hours and days is being watched, documented, and potentially used against you. So treat your personal life like a military operation. Lock it down, control access. And don't give the enemy. And in this situation, yes, the prosecution is the enemy. Do not give the enemy any ammunition they don't already have. Then you come up with a battle plan. Once you've done that, once you've frozen time, once you've paused, collected yourself, obtained the lawyer you need with the experience you need, then you can come up with a battle plan. Here's what that battle plan looks like. Your lawyer should help you understand what's happening, what the process is, and what your options are. They should help you understand the 4 pillars of a strong defense. What they know, what we know, evidence they have, and evidence we could have. This is the framework that strategic military defense is built on. What they know. This is about understanding what the prosecution's case looks like, what allegations have been made, who are the witnesses, what's their timeline. Your lawyer will help you gather intelligence on this. What we know, this is your side of the story, the facts as you know them, the context the prosecution does not have, the exculpatory evidence that exists. This is where clear thinking you did in the first step becomes critical. Evidence they have. This is about understanding what physical evidence, testimony, and documentation the prosecution already has access to. We're talking about text messages, emails, witness statements, forensic evidence. If this case goes to a court-martial, your lawyer will have access to it through a legal process called discovery. A good military lawyer will start building this pillar early through investigation. Evidence we could have. This is about identifying evidence that exists but hasn't yet been collected. Witnesses who can corroborate your version of events. Documentation that supports your timeline. Exculpatory evidence that the investigation missed because they were only looking for evidence of guilt. Your lawyer should also help you understand the institutional pressure that's being applied to your case. Because here's the thing, military justice has changed. It is no longer about facts and evidence. It's about command climate, optics, and political pressure. Your lawyer needs to be able to identify and document that pressure in the critical first phase, because that's what's going to help determine your outcome. And then your lawyer, if they're doing their job right, is going to help you develop a strategy now. That should not be a cookie cutter approach, not a one-size-fits-all defense, but a strategy tailored to your specific situation, your specific goals, and your specific risk tolerance. Because at the end of the day, you're the client. You're the one whose life is on the line. And you need a lawyer who understands that and who will fight for what you want, not for what is easiest for them. Unfortunately, most officers don't get this kind of representation. They get overworked appointed counsel who are juggling 30 cases at once. Or they get civilian attorneys who don't understand the current aspect of military culture or the current aspect of the complexities of the UCMJ today. Or they get lawyers who are more interested in pleading out cases than fighting them. Or they get lawyers who say they've seen it all, but rest on their laurels. And that's why decorated service members with 20 plus years of service are losing cases they should have won. So let's recap what you need to do the second you hear RUMINT about allegations against you. First, stop everything. This is a family emergency. Take leave if you need to. Get somewhere private, clear your head. Second, think through everything clearly. All of your interactions with the alleged accuser or accusers, all of the evidence that might exist, all of the witnesses who might have been present. Map it out in your mind while you still have clarity. Third, find the right lawyer. Not just any lawyer, a lawyer with specific experience in military law and defending serious allegations. Someone who understands the 4 pillars of defense and how to counter institutional pressure. 4, lock down everything. Your phone, your social media, your email, your text messages. Protect your privacy and make sure investigators have to go the proper legal channels. Don't consent. And 5th, work with your lawyer to develop a battle plan. Understand what's happening, what the process is, and what your options are. Then fight. Look, I'm not telling you this to scare you. I'm telling you this because I've seen what happens when senior officers don't follow these steps. I've seen careers destroyed, families shattered, legacies ruined, all because someone didn't know what to do in those first critical hours. But I've also seen the opposite. I've seen officers who understood this reality and deployed systematic defense strategy immediately. Officers who stopped everything, who cleared their mind, who hired the right lawyer, locked down their information, and fought back strategically. And those military members are achieving outcomes that seemed impossible. Charges dismissed before trial, not guilty verdicts in cases where the evidence looked damning, careers and retirements preserved, families protected, and reputations restored. The difference between those 2 outcomes comes down to what you do in the first 72 hours. So if you're in this situation right now, or you know someone who is, don't wait. Don't trust the system to protect you. Don't believe your record will speak for itself. Take action now, because every hour that passes is an hour that institutional pressure is hardening your case. If you found this information helpful, please subscribe. If you know somebody who could benefit from this information, please share. Now that you understand the critical first steps when allegations surface, remember that every decision you make from this point forward matters. Even with the right lawyer and the right strategy, careless conversations can cause real damage. Staying disciplined, staying quiet, and following proper legal guidance is what gives you the best chance of protecting everything